Hello, everybody, and welcome to History Bite number 168, dated January 30th, 2021. I'm Walter, your mobile historian and blue-collar scholar. This History Bite is entitled Pearson versus Murray, 169, Maryland, 478, 1936. For those of you who have never, ever heard of this case, this was the landmark decision from the Court of Appeals of Maryland that integrated the University of Maryland School of Law. Yes, it should come as no surprise to anyone that in the 1930s, up until this very decision, the University of Maryland School of Law was a racially segregated institution, like so many other institutions in Maryland and throughout the South. Okay? Indeed. Of course, segregation existed in the North as well, but for the purposes of what we're talking about in this particular lawsuit, you saw these features primarily in the South. So in Pearson versus Murray, this case arguably was one of the first in America which mounted a direct legal challenge on segregation in higher education. In Pearson versus Murray, okay, Donald Murray, a young man, Baltimorean, about 22, 23 years old, applied for admission to the University of Maryland School of Law, the only viable law school in the state at that time, all right? And due to his race, and exclusively because of his race, Mr. Murray was denied admission to the school. Okay? He received a rejection letter that stated quite bluntly that the University of Maryland School of Law does not admit members of the Negro race. But in keeping with the Supreme Court's decision in Plessy versus Ferguson, the state of Maryland knew that it had to give some type of separate but equal consolation prize. So it informed Mr. Murray that we'll be happy to help you attend law school in another jurisdiction because you can't go here. So, in response to this, Mr. Murray appealed the decision to the University Board of Regents, University of Maryland Board of Regents. However, they affirmed the law school's denial. So because of this, litigation was initiated on behalf of Mr. Murray in the Baltimore City court system against the law school. By the time the matter went to trial, Mr. Murray would be represented by some pretty heavy hitters of the day. One of his attorneys was Charles Hamilton Houston, a very scholarly and prominent civil rights lawyer in that era. And his other attorney was a young upstart, another young black man born and raised in Baltimore, Maryland, who too had recently been denied admission to the University of Maryland School of Law just a few years earlier, all right? Not barely a decade, not even a full decade earlier, as a matter of fact, all right? And he was just getting his legal career started at this point. Want to take a guess as to who that young man was? You got it. None other than the 27-year-old Thurgood Marshall. So, in the courts of Baltimore City, all right, Mr. Marshall made the arguments quite simply that his client, Mr. Murray, was not being afforded a proper, separate but equal legal education by the state of Maryland because Mr. Murray obviously was not receiving the same proportional treatment as white students, first of all, in having to attend law school in another jurisdiction, something that white students did by choice. If the student happened to be from Maryland, white students could obviously attend the University of Maryland Law School. They didn't have to go out of state to get a legal education. But black students in Maryland, that was their only option. You weren't allowed to go to the University of Maryland School of Law. So Marshall argued that this was obviously, unequal. Simply put, no need to get technical or complicated. Black students obviously would have to assume a great deal more, burden to attend law school than what white students would, who could go right here in Maryland, whereas the black student would have to go in another jurisdiction and travel and possibly move. That costs money, okay? The white students didn't have to do that, again, unless they wanted to. So obviously the situation was very unequal. Marshall also made the argument that in having to go to law school in another state, that was not adequately preparing the black law students to giving them the knowledge, rather, to practice law in Maryland's courts, obviously, because different states have different laws. So the individualized knowledge that was needed to practice law in Maryland's courts would not be given to the black students because they had essentially been trained in another state. So once they came here to be admitted to the bar, there would be a whole lot, presumably, they would not know. All right? So Marshall's arguing two main points quite simply. The black students obviously have greater burdens in being forced to attend law school in another jurisdiction because Maryland does not have a separate law school for black students, and they won't allow black students to attend the University of Maryland. Okay? And because law students in Maryland are being trained in Maryland law, the black students having to go to another state are not learning what they need to learn about Maryland law. So these are Marshall's two main points, asserting the unequal status of black law students. All right. So with those arguments submitted, the Circuit Court for Baltimore City ruled in favor of Mr. Murray, and the Circuit Court judge issued a writ of mandamus that the University of Maryland School of Law had to admit Mr. Murray. The University of Maryland School of Law said, yeah, okay, sure, wait and see. So they appealed the matter to the Court of Appeals of Maryland, the state Supreme Court. And the same arguments that were presented in the lower court were presented to the Court of Appeals. All right? And in a unanimous decision by Chief Judge Carol T. Bond, the Court of Appeals of Maryland affirmed the judgment and opinion of the Circuit Court for Baltimore City. Okay? Chief Judge Bond's opinion essentially covered four main points. First and foremost, his argument, essentially echoed the concerns of the appellees here. All right? Mr. Murray, all right, and Marshall, all right? Chief Judge Bond first highlighted, the great burdens and costs that minority students would have to endure by being forced to go to law school in other jurisdictions with travel and accommodations, meals, and everything else known to man. These were things that white students did not have to deal with. White student could go to school right here where he lives, whereas the black student would have to pick up their whole life, and move somewhere else to go to school. Obviously, that is unequal, very unequal. All right. Next, Chief Judge Bond pointed out that because the state of Maryland has decided to allow individuals to obtain a legal education per se in this state but only allow whites access to a legal education and deny all non-whites admission to the school exclusively because of their race. This was a clear violation of the 14th Amendment to the U.S. Constitution and its mandate for equal protection of the laws. Okay? Very simple. Very, very simple. All right? Number 3, as the state of Maryland had no law school for black students, black or otherwise any minority students, okay, and the state had shown no desire or initiative whatsoever to build one, it was not within the authority of the court itself, the Court of Appeals, to order the state to construct one. All right? Chief Judge Bond was not about to go there, so he argued that that was an insufficient remedy. All right? So, the court can't order the state to build a separate law school for blacks. So last but not least, in summing up the 3 main points, we get to point number 4. Because the state of Maryland has decided to allow for individuals to obtain a legal education here and has only given whites access to a legal education here in Maryland, denied all minority students, in this case, we're focusing on African Americans, admission to the school, all right, in order to satisfy, the equal protection requirements as required by the U.S. Constitution, all right, and the standards set in Plessy versus Ferguson, separate but equal. Because the state of Maryland has no separate law school for blacks, the Court of Appeals ruled that Mr. Murray had to be admitted to the University of Maryland Law School, okay? And from that point forward, the University of Maryland School of Law was officially integrated, all right? So, Mr. Murray thus became the first African-American student to attend the University of Maryland School of Law since it became racially segregated in 1890, all right? So again, the Court of Appeals holding in this case was that because the state of Maryland had decided to allow individuals to obtain a legal education, all right, but only allow whites access to a legal education in Maryland and had excluded all non-whites, all right, from the one law school that we had and refused to build a law school for non-whites, the only way to satisfy the Constitution's requirement for equal protection and the standards set in Plessy at the time for separate but equal, the only way to satisfy those conditions was to allow black law students and other minorities by virtue of that admission to the all-white school, University of Maryland School of Law. All right? So that's that. Interestingly enough, outside of this specific case, this decision did not have a tremendous amount of far-reaching impact. All right? A few years later, the same arguments were used against public schools in Baltimore County, but the petitioners failed in their pursuit. The Supreme Court itself, for the record, this case was not appealed to the U.S. Supreme Court, so it remained only binding upon the state of Maryland. And I'll also add that the Supreme Court itself would address this very issue of states refusing to admit certain students to their law schools, but paying their admission to attend in another state. The Supreme Court would address the constitutionality of that in the landmark decision of Gaines versus Canada, 1938. All right? So my time is up for now. But if you have any questions or controversies, please leave them down below and I'll be happy to answer them. If you have not subscribed to my YouTube channel, please do so right now. Just hit that little red subscribe button and the little bell and we'll be in business. Thank you again so much for listening. Take care, stay safe out there, and I'll talk to you at the next bite. Peace.